Hi, my name is Tori Hirsch. I'm an attorney at the Nieves Law Firm, and this video will discuss what is a petition for a writ of habeas corpus. First thing I want to say is the language here can be really confusing, and I hear the word habeas corpus a lot, I hear the word writ a lot. When your attorney is seeking this kind of relief, what's happening is they are writing a petition for a writ of habeas corpus. And once that happens, the judge can decide whether they want to hear it or not. And after that, if the judge is like, sure, let's move this case forward, then the other party, which is different depending on who you are, where you are, will write a response. But to be a little more interesting, what is a petition for a writ of habeas corpus? It's basically a request to bring something to the court's attention. And in most cases, this is a request to bring something to the court's attention that you believe would have changed the outcome of your case. There's other contexts when you can do a petition for a writ of habeas corpus, like if you're somebody who was in prison, but you are now out on parole and you want to change something about your parole. You're going to do a petition for a writ of habeas corpus because you're technically still under the jurisdiction of CDCR. And when you want relief from CDCR, you've got to write a petition for a writ of habeas corpus. But in most cases, what this is bringing that issue to the judge's attention, and it's something that you can't have raised in an appeal. And that's where I think the distinction gets really interesting and very important, because when you're bringing an appeal, that's something that happened within what I like to call, what my law school professor called the four corners of the record. And I don't know why, but doing this really helps me remember, even though it doesn't change anything about what I said. So when I think about the four corners of the record, I'm thinking about what happened in the courtroom. If I were to order a transcript of your trial and read through it really, really carefully, and I picked out issues that I thought could be addressed in front of the judge, every single one of those issues would likely be something you can bring up on appeal. Something went wrong, something was brought up and it shouldn't have been. A law was used and it shouldn't have been, or it was used in the wrong way. When we're talking about an appeal, we're talking about things that didn't show up in the record, but should have. And if they had, they would have made a difference. So if you were convicted and a lot of the evidence at your trial had to do with science, for example, and now you've been incarcerated for 20 years, and there's all this new science showing that, hey, when we were doing whatever scientific method back in the year 2000, it was bad. A lot of those results were bad. They were false. They led to a lot of false convictions. That's where you want to do a writ of habeas corpus and say, hey, judge, I was convicted based on this. Doesn't look like that stuff is good anymore. I deeply believe that had the judge had access to this, or had the jury had access to this, the outcome of my case would have been very different. Can you please take another look? This is also true if somebody has a new witness come forward, or a witness who wants to change their story come forward. So if you're somebody who loves somebody, knows somebody, is fighting for somebody who's incarcerated, and you want more information about petitions for writs of habeas corpus or other types of post-conviction relief, then you should absolutely call the Nieves Law Firm at the number below. We're looking forward to talking with you.